Hi, good afternoon, everyone. My name is Anna Melandra. I am the Director of Marketing for Volpe Koenig. We're a full-service intellectual property law firm in Philadelphia. Welcome to our June 10th webinar. 10 things in-house counsel should be teaching inventors about patent prosecution. This course has been approved for CLE credit by the Pennsylvania CLE Board. Now, Volpe Koenig will report your attendance to the Pennsylvania CLE Board's online portal, and the attendees will be issued certificates of completion. So we have a built-in reporting system within the platform that shows timestamps. So that verifies your attendance, so you don't have to do anything. So just please stay on the webinar until the end, so your timestamp will reflect the time and show that you attended the whole course. Now, if you haven't already downloaded the course materials, you can find the PDF of today's presentation in the handouts pane. It says handouts. There's two handouts in there. One is the course materials, which will be presented, and the other is an evaluation form, and we would appreciate you also downloading that and then sending that in after the session is over. So before we get started, just a couple housekeeping notes. Everyone has joined the webinar in listen-only mode, which means that you're muted. So we're looking to make this webinar interactive. So if you'd like to ask questions of our presenters, go ahead, pop that into the chat, pop that into the questions, and and I'll moderate, and I will let the presenters know that there's a questions, and we'll take questions throughout, or you can hold them at the end. There'll be time. And now I'd like to turn over the presentation to Volpe Koenig attorneys Wes McMichael and Ed LeVar.
Thanks, Anna.
Thanks, Anna.
Hi. Thank you, everybody, for coming. Looks like we've got pretty good turnout, and this is a topic that is near and dear to myself and Ed. My name is Wes McMichael. I'm a shareholder of Volpe Koenig in the electrical group. I have been doing patent prosecution for probably 17 years now, primarily in computer science, telecommunications, electrical world, but I have a physics background. So over the years, I've gotten into a variety of different technologies. I would say kind of everything except for the pharma life sciences world, but even that, just a little bit of it. Ed, you'd like to introduce yourself?
Yeah, hi, my name is Ed LeVar. I work very closely with Wes, and we have somewhat similar backgrounds. We're both in the electrical department, so our practice focuses pretty heavily on that sort of thing. I started my career as an engineer in the field of integrated circuit design, and I was a patent examiner in the computer graphics arts before I entered practice. And I've been doing this for over a decade, and I've been with VK for about 7 years now.
So inventor training, we'll jump right into it. It's a topic that is near and dear to Ed and I, and we have several clients on this call and are on this web. It's sort of interesting. I think through our variety of clients, from very strategic, all in patent dependent clients, to manufacturers who are just filing defensively with fixed fees, and across the board we see a huge range of inventor training going on, and knowledge based in the inventors, and we think that it's one of the biggest contributors to cost in a patent, or if you're in the fixed fee world, it's a big contributor to quality. Is if your inventors know what they're supposed to do, know how to participate, then you're going to get better quality for more efficiently. So this kind of just shows the motivations, but it sort of works out to be the same for outside counsel and inside counsel. You get more efficient prosecution, and you end up with a higher quality product, which is the goal for everybody. And then from an inventor standpoint, oftentimes they're sort of indifferent to the patent process. They know they have to do it, but it's like a side job. They're not that into it. So if you can get them engaged and get them trained up on it, they'll end up in a better place for you. So I'm just going to do an initial poll question here, and if you can launch the poll question, just curious how often you're providing inventor training on patents and patent prosecution. we'll give you guys a couple minutes. Maybe not. That's probably enough time to answer the question, I would think, if you're following along. So gonna keep moving. Can we see the results? Let's see.
That's interesting. Interesting results.
All right. Yeah, that's probably more than I would have said was regularly, although yearly is regularly. I mean, that's pretty good. You know, what Ed and I have seen, and you can put those away now. I don't know how to do that. So, you know, what Ed and I have seen, and one of the reasons we wanted to do this presentation is that a lot of times we talk to inside counsel and they tell us like, oh yeah, I've been tasked with doing training for the inventors. I'm not really sure where to start. And, you know, or sometimes they just say, hey, can you do this? And we do it happily. We often will do, we don't charge for it because we believe in it. So we'll go to an inventor facility, or more recently we'll host a webinar where we go through and do training. And, you know, I think from inside counsel perspective, it's sort of like this nagging thing, you know, you're supposed to do, but maybe you're not getting to it as regularly as you should, or it's just too much time consuming to really put together a good program. So the kind of format today is we've identified 10 kind of frequently asked questions that come up in prosecution that we frequently, again, depending upon the knowledge base of the inventors, like, we can't start to have a conversation about an office action until we have a conversation about what an office action is, or you know, what is prior art, or that kind of thing. And these are things that they should be getting from training somewhere. And so this deck will show you the question. It'll give you the legal background that you need to kind of hold up on. You know, what's the relevant law for these questions, and then it'll give you the inventor answer. And these are kind of intended to be, I hope it's helpful for everybody that's sort of tasked with inventor training. They'll give you a template set of slides for these questions and how to answer them. And you can take them, we'll give them to you afterwards. You may be able to download them now. And you can take them and you can doctor them up to make them specific to your process. Because I know every client's process is different. They have different meetings, they call them different things, or they, you know, sometimes they don't want the inventors to check in on the stuff. Sometimes they want the inventors involved in every step. It varies wildly, and I'm sure it fits your business model, but these will help answer very common questions. And then I guess, so one thing it's not going to address is the IDF, which is actually like the most important thing. Ed and I did this last year. We covered it last summer. We did a separate webinar just dedicated to training your inventors to fill out an invention disclosure form. We provided a sample invention disclosure form that we developed in-house, and then we provided a slide deck to kind of teach your inventors how to fill out an invention disclosure form and the various different steps and important features. So that I think is paramount in saving costs and increasing quality through inventor training. It starts with the IDF. This webinar is going to focus on everything after that IDF is turned in. So just, by the way, and if you're interested in the IDF webinar, we have it recorded. We also have the slides. We have a sample IDF form. All that, if you want to just type your email address in the chat window, we can send it to you. If if you'd rather just follow up later with email or call or whatever, we'd be happy to send it to anybody. It's really just intended to kind of help. And again, it's a template. You're going to have, based on your technology, your practice group, your patent goals, you may have different things that you want in your IDF. So all that saying, we'll set the table. So let's jump into our first question is a very basic one. Can you give me an overview of the patent prosecution process? And you get this, and it's, we get it a lot when we get a new, maybe more green inventor on there. But we get in different forms of, how do I review a draft application, or what do I need to provide? What are the odds of successfully getting this? How long will it take? When can I expect to get a patent? What's a PCT application? Where, I want to file is it getting filed in China, or is this a worldwide patent, or, all kinds of questions. So for this slide, having set the table, I was going to give you the more detailed legal background. For this slide, I think we all know it's a very basic question, and we've all been practicing in this area. So we see, the sources for all these answers is 35 USC, it's the CFR, it's the NPEP, the PCT, and of course, various laws of countries around the world. So there's a huge knowledge base that you have that you could pull from to answer this question. But what we find inventors want to know is they want to know the timeline. They want a flow chart. And I remember that from sitting at the patent bar. Like, I just wanted a flow chart that showed the whole process, so that I kind of knew, when different things happen. So they want to know these timelines, and then more importantly, they want to know, or we want them to know, when opportunities for amendments exist, so that they can check in and provide updates on the product or the standard that you're targeting, or the market landscape, or whatever your business purpose is for having the patent. You want to know at what points, what kind of updates are going to come from the inventors, and you want them to know when they should be providing them. And then finally, I like to give the inventors a relative cost of prosecution activities. I think they appreciate it, because I think they just know patents are expensive, and it kind of wakes them up to think, oh, okay, you didn't think this was a significant event, but it is. It's expensive. Now, without getting into dollars, because then they're going to want to raise and realize how much the company's spending. So what we've come up with is a set of slides here. And you'll notice here at the top, we call this the training slides. So that means that's to call out that these are not really for this audience. This is for this audience to use in training their inventors. So here's a flow chart of the pre-filing, and down at the bottom, this is kind of like inventor activities here, meetings that they may get called into. And again, you may have specific meetings. You may have a pre-disclosure meeting. You may have a harvest meeting. So whatever it is, you could change these to kind of fit with your business. And then up top here, this is sort of showing at what points are you able, are we going to be looking for an update on the legal landscape? So this is showing with the U.S. provisional. You may not use provisionals, in which case you can change this. It's all done in PowerPoint. So this is just kind of showing. And then the other feature is these money bags here to sort of show. And this was done with the idea that you were filing a dual PCT U.S. application. So there's more money bags on the U.S. because that's where the attorney time is being put. But if it was just PCT, you could change it. Just to sort of show. So this is the training slide for kind of the patent timeline after it's filed, right? So anytime before the first office action, it sort of shows that there could be this review loop. As a meeting, oftentimes, we set up meetings when we get that office action to talk to the inventors about it. But maybe you do it differently. You could around and change it. So this is all just to sort of show the process and give them an idea that, okay, yeah, this costs money, so I should pay attention. And here's the PCT timeline, right? Which I think, this is one over here on the national stage. I think it's important to hammer home that at 30 months, we really need to know, is this good or not? So, if it's not in the product anymore, you need to let us know at 30 months, because that's when we're gonna throw down, $5,000 a country to file it around the world. So, but again, you can doctor these up however you want, and you can change them. But this is sort of just a rough idea of a way you could present to your inventors an overview. So, questions that inventors are going to ask: how can I help in this process? And these are sort of the obvious questions. Review attorney drafts in that process, make it a priority. Prioritize the patent work. Be prepared to teach your attorneys the technology, because almost always the inventors need to teach us something. So, and then beyond that, after filing, keep up with new developments in the market and update legal. Don't just wait till 10 years from now to tell us that it's not in the marketplace anymore, because there's places to save money all along there. And then knowing how it fits in the strategy. So these are just kind of fun. And again, you can share these examples with inventors, but they're entertainment for patent lawyers too. So this is inventor review. Also, a lot of attorney review gone wrong, but these were exchanges that made it into even issued patents, you know, and applications, and, you know, places where the attorney asked the inventor a question and it doesn't look like it was answered, or you know, or if it was answered, it was left out. By the way, I also, it's a good time to say, you know, I think this is an old school way of communicating with inventors, and that Microsoft Word comments, it makes a lot of sense for exactly this reason. And then this is one right here. So providing user interface display and an image forming apparatus, which is really a bogus claim included amongst real claims, and which should be removed before filing, or in the claims included determine if the inventor actually read the claims, and the inventor should instruct the attorneys to remove the claim. The amazing thing to me in this is that this is in the claims and it made it into an issued patent. So I think it also checks the box of did the examiner read the dependent claims. So Ed, maybe you've got a comment on that.
Yes, well, 3 different people reviewed this claim, at least 3, and it still made it into an issued patent.
Yeah, and then the one on the other side, I'm sorry, babe, but I may actually have to be here late. I've got to get this patent application filed today. That was in all the blogs. I think it was maybe a 2016 patent. I remember when that one was out, and it was, you know, it was the funniest thing to happen in patent law in years. But shockingly, I checked this week, and there's been no COC filed on that. I think I would be quick to get that in there.
I hasten to add that none of these are our cases.
Yeah. In case you're a client on the webinar and you're quickly Googling the patent numbers, none of them are DK clients. So you can breathe easy. So, you know, just key takeaways from the inventors is the costs grow exponentially during the patent life cycle. So I think that's an important concept for inventors, because you need them to be checking in down the road. And then opportunities to amend during prosecution, you know, are limited. So we want to know when they happen, and, you know, obviously do your review. So spent a lot of time on that one, but that's a big topic. And I think just those timelines can really illuminate a lot of stuff to the inventors as to why they're getting called by outside counsel or whoever for consult. So with that, Ed, you take questions.
Okay. Yeah, I'll take the next one and give you a chance to catch your breath. So the next question we get a lot. I guess these are in no particular order, but sometimes inventors will ask, you know, what's actually protected by the patent, and this comes up in the context of, you know, maybe they've seen a competitor's patent and they see a figure in it and it makes them panic a little bit, like, oh, you know, how did they get a patent on that? Or I don't think this is patentable. Or can we use this? Can they use this? It comes probably basically from a lack of understanding on the part of inventors about what exactly is covered by a patent. And if we go to the next slide, the legal background to this is essentially in 112. You know, as everyone on this call knows, that the claims are what delimits what is protected by the patent, of course, in the context of the specification. So I have some quotes from the Phillips case here, useful quotes that set that out plainly, that the claims are what define the invention, and that, you know, the written description doesn't delimit those rights, but, you know, it provides context for the claims. And if we go to the next slide, yeah, so this is a quote you'll see a lot from examiners in office actions. It said it's important not to import the claim limitations that aren't part of the claim. And all of this is just to set up, you know, the inventor training slides, which will be next. So what you want to do is give the inventors a little overview about how to look at a patent and understand that just because they see something in a figure or something like that doesn't mean that that's necessarily what the patent protects. So this is just a little basic overview you can give to the inventors, say, you know, to let them know that there's a lot of descriptive material in there, but yeah, you have to look at the claims, and that the meaning of the claims, you know, is based on the description, but you don't import those limitations into the claims. And if you go to the next slide, I have just a couple of fun examples that, you know, that are usable to kind of like, so this is like a one-liner, you know, fake claim, you know, a seating device comprising a seating surface connected to 4 legs. This is a pretty canonical example. You may have heard it before. So, you know, here's a picture of it. It's hard to see the 4th leg, but that chair infringes because it's got 4 legs, whereas the stool doesn't infringe because it's only got 3 legs, doesn't have 4 legs. And then if you go to the next page, we have the claim with 3 legs. So now both of those things infringe, but the 2-legged stool that's leaning against a tree and then the 1-legged stools there don't infringe. So these are just some kind of fun examples you can use if you want to give inventors an idea, a flavor of how to read these things. So if we go to the next slide, we have our next poll question, which kind of relates to the first poll question, which is who provides your inventor training? If you answered that you don't do training, then I guess you can answer it that way again here, but it'd be interesting for us to hear, who you use. Do you do it? Do you have us do it? Or, is there some other thing you do like HR? I mean, obviously there could be other kinds of answers, but maybe just another few seconds on this one, because this should be pretty easy to answer, and then we can see the results and find out. Okay, in-house does it, or they don't do it at all. So I guess a lot of people aren't taking advantage of the possibility of having outside counsel handle it. But if it's something that interests you, get in touch with the Wes or I, and it's something we can talk about.
Yeah, I mean, it's something that we do for clients. We'll offer to do for clients, and we can take these presentations and tailor them directly. But if you're using a different firm, I would highly encourage you to, beat them up and get them involved in the process, because they can certainly help, even if it's just to help prepare materials for you to do the training.
All right, so that takes us to our next question. Another question you'll hear is this privileged and confidential? I mean, they don't ask it like that, obviously. They'll say something like, is it okay for me to send this material to you? Or is this just between us? The idea is that, a more savvy inventor might, they might be worried that there's something that they want to keep from becoming public. And then the approach here is to train the inventors on some basic hygiene for maintaining the privilege in communications, particularly email. So the legal background to this, I have a couple of cases, federal circuit cases here, that just lay out the basic criteria for attorney-client privilege. Opinions on law or legal services, assistance in legal proceedings, for example, preparing patent application. And then I have some explicit law here about how invention records are privileged, as long as they meet certain criteria. And the next slide, here's some case law about the privilege extending to patent agents. That wasn't necessarily a given, but it is in federal circuit law if you need to establish that for some reason. And so the next slide.
Provided that it's the patent agents practicing before the patent office.
Yes, exactly. Yeah, and you'll see there in the case law, it's in all, for patent agents, it's in the context of their remit, for practice before the office, as opposed to the attorney privilege, which is more general. And then the next slide gets to this is a Third Circuit case, talks about how the privilege can extend to agents, in this case not patent agents, but your secretary, people that need to have access to this information for the law office to function or for the legal department to function. So there is law for all of this. And if you go to the next slide, here's maybe a little easy training slide you could use, you could adapt. Just it kind of says the same thing in more lay terms, which is, it's important to ensure that the communications are privileged as far as possible. And then we'll talk about some circumstances where the communications would be privileged, communications with an attorney, as long as it relates to legal advice, or with an agent that relates to preparation of the application, that it includes the law office, and then some examples of, emails. And then the next slide, I have a couple of examples of communications that might not be privileged. So if you're talking to your patent agent, but it's about golf, it's not about preparing the patent application, that's not privileged. Same thing with attorneys, things that aren't legal advice. And then, you could be copying a non-attorney on this, and that could break the privilege also. So that's kind of what is outlined in these slides. So if you go to the next slide, it brings us to our next topic.
Okay, so this is one that the inventors get excited about, because they all have various different incentive programs, which we may talk about. But who should be listed as an inventor? And you hear the classic stories of, oh, there was a CEO that put himself on every patent application they ever filed, and was that right? And so sometimes you get, he's my supervisor, or they just assembled it. It was my idea, and all those kind of things that come through. So, we're gonna skip this one. We had a fact pattern, but I don't think it's in the right. It's not in the. Okay, we're skipping that. Okay, so in the legal background, right? So inventorship stems from the elements of invention, which is conception and reduction to practice. And so to be an inventor, though, you need to only be involved in conception. So it's who conceived the invention. It doesn't matter if you are only involved in reduction practice. So if Ed designed it and I built it, Ed's the inventor. That's kind of like a fundamental tenet here. So, we can get into what is conception, and there's pretty good law in this Burroughs case. And again, the inventor didn't need to know it would work, and the level of contribution is pretty low. It's very low, in fact. You have to contribute to the joint arrival at a definite and permanent idea of the invention, but what is that level? There's no explicit lower level of that contribution. So, and then also kind of more practically speaking, okay, well, she told me about conception, I knew that, and okay, that'd be a little bit of a limit. But what are the risks here, right? As inside counsel, that's the question you're worried about, and there's a lot of case law where someone got left off, and then they came back later, usually not as an employee anymore, sometimes as an employee, and said, hey, I was supposed to be an inventor on that. You owe me half, you owe me whatever. You left me off. I want my invention back. And, here's all its evidence, whatever it is. That's the risk, right? So there's very few cases where someone comes forward and says, hey, you put me on there as an inventor, and I'm really upset because, I didn't want to be on that one. I'm sure it's happened, but it's never happened to the point where someone actually litigated it. So, it's a good idea to vet who the inventors are and give the inventor some training, but when in doubt, you want to keep it in. So from a training, we talk about, we always ask that you're contributing to the claimed invention. So this is something that, outside counsel should be, they're going to come to the question on the IDF. And at that point, in truth, you don't necessarily know because you don't know what actually the claimed invention is. So at the IDF, everybody that contributed should be on there. Arguably, when you file the patent, you may get to the point where actually somebody contributed to something else and it didn't end up in the patent application. It didn't end up getting claimed. I still think it's better, it's safer to ask the question, can you identify at least one claim that you contributed to? But from a risk standpoint as inside counsel, you're better off just to leave them on. The other scenario I've always thought about with this, contributing to at least one claim, is that if you have an inventor listed, you then determine actually we claimed a different embodiment, there shouldn't be an inventor on it. That's fine, but if you drop them off that and then you subsequently file a divisional and you claim their embodiment, then they need to be put back on. I think again, it's because there's low risk to leaving them on, I would leave them on. So these are just a couple, kind of fun examples that you can use with your inventors to kind of run through hypotheticals. So, Ed conceived the sandwich, and essentially I bought a loaf of bread and built the sandwich. Even though I built the sandwich, I reduced the sandwich to practice. I'm not an inventor. I just did the reduction to practice, and Ed is the inventor. In scenario 2, I actually had an improvement where I put peanut butter around the edge to seal the jelly in, and now we are co-inventors because we claim this idea that it's a sealed sandwich used with a ring of peanut butter. So those are just good examples that, and you can definitely take these slides and make your own examples that are specific to your technology, but these are ones that everybody can understand. And,
all right, so the next topic is, how do I comply with the duty of disclosure? Now, this comes up this comes up for us in the context of new inventors who are getting an email from us that has some boilerplate that lays out the duty of disclosure, like you have this obligation to the USPTO. And of course, they have no idea what that means. So it is helpful to provide a little training on this. And the questions that arise is, do I need to go search for patents to comply with this, and then they have access to documentation. They want to know if they should be, they really don't know what they're supposed to provide or who to provide it to or when. So if you go to the next slide on this, basically the rules for this are set out in 37 CFR 1.56. This is just the who, the what, and the how of it, which is this sets out the who has this duty to the patent office to provide information. So that's the inventor, the agents and attorneys, anyone else who's substantively involved, applicant, assignee, or assignee, people who are obligated to assign. And the duty is to provide material that's material to patentability, that's not cumulative, that establishes prima facie case of unpatentability. I think everyone probably is familiar with this stuff, but it's good to have it kind of set out right here. And you can click to the next slide. I have some case law here about the consequences. We're really more keeping it in perspective. Yes, you have this duty, and yes, your infringer is going to, if you didn't cite something, is going to say that you've engaged in inequitable conduct. But they're going to have to prove that you knew of the reference, you knew it was material, and you made a deliberate decision to withhold it. So keep the risk of it in perspective. Here's some defensive material. So here's a training slide for the inventors. That this breaks. That was all very technical, but this is really kind of the nuts and bolts they need to know. They need to know that they have this obligation. They need to know it's a continuing obligation, that they can be asked about it, at different points in the life cycle of the patent. And really, they just need to know if they're aware of any patents or materials that might relate to the invention to tell us about it. Tell Wes, tell me, tell the in-house counsel, hey, I have this document. It's really close to what we've been working on. I'm giving it to you, and then I've satisfied my duty. You should also tell them that they're not obligated to conduct the search for any of this material. This is just, if you know it, if you have it, let us know, and we'll take it from here, sort of thing. This is also a good opportunity to ask them to provide PDFs up front. This is just for convenience for us. They usually have this, and so if they just give it to us right away, it saves some back and forth, and we can submit it with the IDF. So if you go to the next slide. That takes us to our next topic.
Okay, so this is a pretty easy one, but again, it's a good thing to include in any training you do for your inventors. Are there any online resources I can use, and what do I need to know how to use them? And again, this is often the inventors want to know when their patent gets allowed, and I've definitely had inventors at big companies that they would call me periodically. I'm sure their legal department didn't know they were calling me, and if I'm just checking the status, but I probably wasn't billing them, but I was probably getting annoyed at them. So just something to think about. Your inventors are anxious. We want them to be engaged in the process. If they have the tools to check things like that, they can help and learn more on their own. So from a law standpoint, again, there's not a lot of law here. Obviously, publication, fact that everything's public, that's pretty basic stuff. 18 months, inventors should know that after 18 months the applications become public. That's important for them to know, and then how it becomes public is in the tools that you want to teach them to use. So from a standpoint of like, what do inventors need to know? They need to know the difference between, they need to know what they're looking at, right? So they need to know the difference between patent applications and granted patents. They need to know when they publish, right? So they publish applications publish after 18 months, and patents publish on their grant date. Patents of 7 or 8 digits long. Applications are longer numbers with a year at the beginning. And also because because applications are often referred to by their application number, like again, like we need to give them the vocabulary, right? And maybe this should be earlier in the training process, but I like to put this slide up with inventors and kind of walk through. Sometimes I'll highlight other stuff, other pieces of information here, but this is the big one. If you're just trying to teach them how to find patents and check the status of patents, this is a good way to show it and just give them the vocab to look at a patent. And then I like to give, I wish there was, a more flashy tool than Google Patents, but Google Patents is our, one of the bedrocks of our profession at this point. So I like to teach inventors, and smaller clients that don't know about it or whatever. This is a great way for them to, obtain patents, look them up, perform quick searches, kind of rough searches, that sort of thing. Check the worldwide status. We've got publications around the world. You can see what claims even are in a lot of jurisdictions. So that's, Google Patents is an incredibly powerful tool. If you get more advanced, kind of, Inventor Training 202 is going to be, teaching them how to jump between cited art and look at forward citations and back citations or things like that, and really kind of learn to search more than just, typing in key terms. And, so Google Patents is a critical tool at this point for inventors to know about. And then again, maybe on the more advanced side, but when you have that inventor that's obsessively asking for the status, or wants to see what the examiner wrote, and you're just not set up for the, attorney reporting to go to inventors or that kind of thing. If they learn to use public pair, they can get in there and find everything they want to see, and probably maybe more than they should. But I know a lot of inventors that use it, and it's always refreshing when they're like, oh yeah, I already looked at that office action, or you don't need to kind of stand where to get it. And then really this is like the status checks. So, Ed?
All right. Oh, so this one is near and dear to my heart, especially. So do we need to provide you with figures? I think to all the experienced practitioners, this might not even occur to you as something that needs discussion because everything has figures. So I've had this from inventors, and this actually also provides a good opportunity for some detailed training that helps efficiency in the patent application process. So I had an inventor who provided me with a disclosure that was over 100 pages long, didn't have a single figure in it, and I mentioned to him that we might need to develop some figures for this, and he did not think it needed any figures. Well, it's all right there. It's all described. What do we need any figures? Okay, so to give the legal answer on the next slide, I have a little bit of the legal background to why you'll need some drawings. 35 USC 113 requires that when the nature of the subject matter admits of illustration, those are the magic words, by a drawing, the director can require its submission if you haven't provided it. Now, everyone, I don't think anyone here has ever submitted a patent application that didn't have a figure, but on the off chance that you did, and the office decided that you should have, you're putting yourself at risk of not getting your filing date. And then, because you can't fix it, you have to fix it later. And so you're going to get a later filing date, and that could be really catastrophic. So, you can tell the any kind of inventor who doesn't want to submit any at all that they're putting their patent in severe jeopardy. But apart from that, if we move to the next slide, this is actually just some more just detail about the legal requirements from CFR 37 CFR 1.81. Just talks about when the drawings are necessary. And at the bottom there is more about the risk of insufficiency of this specification due to the lack of enablement. But if we move to the next slide. Now, even more background, legal background. So yeah, so it's the OPAP that does this review. This is even before it gets to the examiner. So these are people who, kind of like a paralegal is going to look at this, and they're not going to put a lot of thought into it. They're going to say, well, this doesn't have any drawings, so I'm not giving you your filing date. So definitely don't risk that.
I can tell you've been officially burned by the inventor that didn't provide drawings. So
I spent a week of Christmas on that case. Yeah, but even more to the point, and I know you and I have discussed even these very slides before. This and the slide after it are some great inventor training slides, if I do say so myself, because so we like to ask the inventors not only just to give us a drawing, but to give us something very specific. I want at least one diagram that illustrates the invention and shows the parts that they consider to be new and where it fits into the outside world. So here's some examples right here. I mean, there's a picture of the seat there, but like if it's a new CPU, I want to know how it connects to the computer system. If it's a new cell phone component, I want to know how it communicates with the network. If it's a new memory cell, I want to know how it functions with memory in the DRAM. If it's a new gripping tool on an endoscope, I want to know how it functions within the existing endoscope. And I said the picture is worth 1,000 words here, because if they don't give that to us, I mean, I'm going to prepare that, but there's going to be a lot of back and forth. It's going to take a lot of talking, and I might not get it right the first time. And so that's going to be 1,000 extra phone calls with me and 1,000 extra dollars, and 1,000 less quality, or efficiency, certainly. Now, one thing that we do is on the next slide, not only do I ask for a diagram, but I ask for a second one too. And what I want to know is, because this is something that's easy for the inventor to provide also, it should be, preferably in a flow chart, I want a second figure that shows how it works or how to make it. So it relates to the first figure. So the first figure is what it is, second figure is how it works or how you make it. And that picture is worth 2,000 words, because again, of course I can create this, and I'm going to be creating things that are more detailed than anything the inventor provides. But if they give us something that's solid from the start, it just it makes the rest of the conversation just much easier and more efficient. And then we can focus more on the technical details of drafting, and it increases quality and keeps the budget in check for sure. So let's, I guess our next topic is the novelty and obviousness. This is a big one, right, Wes?
Yeah, this is a big one. This is so some of the, you kind of get the sense of with this, that, you can see with some of these, it's really clear drawings, providing drawings. If you don't provide drawings, it's going to end up, costing the attorney more time in drafting it, or it's going to lead to, lower quality applications. Somewhere something's got to give. So that's if you go back to our IDF form that we presented last summer, it's got questions. It asks for 2 different drawings, and it really tries to solicit the inventors to create those figures. So again, if your inventors don't typically prepare drawings as part of their IDF, think about adding that on there so that question comes out. So all right, so now we're on to kind of advanced inventor training here, novelty and non-obviousness. And these are tough topics. Well, novelty is not that tough, but non-obviousness to inventors is, I've had, hours of long conversations with them, probing me, because they want to understand it. They get a rejection, they feel rejected, and they want to understand why someone would think their invention was obvious. So it comes in a lot of different ways, but very often it's when that office action gets in the first time they see a 103, or the first time they don't agree with a 103 anyway, and they're like, I had one recently, there were 5 references, and the inventor looked at me like, how can it ever be possible to be find 5 things? That was essentially our argument at the patent office. We're going to an appeal now. Anyway, so obviously, the background, it never hurts to refresh on these. Obviously, 102, we, near and dear to our heart, and there's a lot of case law on 102, but I think that.
Wes, we have a question.
Oh, we have a question. Okay. Sorry. Screen change.
Sorry. How do you handle the 101 subject matter issues with the inventors?
I think the question is jumping ahead to well, we're talking about novelty and obviousness. How do we train them on subject matter?
Yeah. So we did skip over 101, and Ed and I talked about that quite a bit, and I think so. 101, patentable subject matter. You know, I will say to inventors, okay, it needs to be useful, but trying to get into more advanced 101 type issues gets really sticky with inventors, and unfortunately, I think that this is where, you know, you want your attorneys to handle it. You don't want your inventors deciding, you know, oh, should we file this or not? Because, like, I heard software is not patentable, you know, and that kind of thing. So we try to train the inventors to provide the information that will make it, you know, how does this invention touch the outside world? Show me a drawing of how it touches the outside world, and that sort of thing, so that hopefully, you know, the attorneys are going to handle the 101 type stuff. Do you have anything to add on that?
Yeah, and that really comes up in, I mean, obviously, well, I guess I shouldn't say obviously, maybe a sophisticated inventor, but so this 101 would come up just in that context, like, is software patentable? They wouldn't ask, you know, what's, you know, 101, unless I guess if they were reading the office section and they saw a 101 rejection. Fortunately, we've been getting a lot less of those. We've been, you know, because the law has become, or the patent office procedure at least, has become more favorable, and we've been getting more sophisticated about how we handle that issue. But yeah, maybe on a more ad hoc basis as far as training for that issue, whereas the novelty and obviousness is a little more nuts and bolts.
Yeah, I was going to say, I think that the training, you know, probably has a place with certain clients that are, you know, very heavily on the software and you know, or just like algorithm type side, and then but even there, like, it's going to be different training for, you know, the people that are rating drivers through, you know, an algorithm versus the people that are, you know, scoring cable technicians and you know, in their craft. So I've, you know, there's 101s popping up all over the place, but it's an attorney issue at this point. The other thing, it's a moving target, it's dynamic. So I guess the short answer is we don't, unless we really need to. And that would be like for a specific client, we would do 101 training. I do know, you know, very seasoned inventors that are sort of up on it a little bit, but even then they're still not comfortable with it. All right. So, but thanks for the question. That was a good thing to cover. So moving on to 102, obviously this is pretty straightforward. The quote at the bottom, you know, this I think is underlying the part that you know, patent is invalid for anticipation if a single prior art reference discloses each and every limitation of the claimed invention. I'll say I write that in almost every response I do for a 102, and I think it's very easy for an inventor to think about that, and I'll show that when we get to the training slide. But, so then obviousness is obviously more complicated, and inventors often have a hard time with sort of the subjectiveness of it, and so, you know, you could show them the code, but they're not gonna want to hear that. I think that Graham v. Deere, obviously, you know, the seminal case in obviousness, and I think they do a good job explaining it sort of at a level that inventors can understand. And particularly, I find that when I'm trying to overcome an obviousness rejection, that the secondary considerations that Deere lays out, I think are really useful for explaining things to inventors. You know, they understand, you know, unsolved needs and failure of others and that sort of thing. But then, you know, oftentimes that's not the argument you're making in the end of the day. But when you have that conversation with the inventors of like, why didn't anyone solve it, or, you know, why you can eventually arrive at a structural difference or a physical difference, or, you know, a patentable difference, as I say, that you can argue rather than just arguing the secondary consideration. And then obviously KSR, you know, more more current law than Deere. But I think this second quote down here sort of is another good way to explain it to inventors that, would, if you updated the prior art with your sensor, would that be patent? Would that, would somebody of skill in the art have arrived at the same solution if given the prior art, right? That's sort of the European standard, but I think it's a little easier to understand from particularly in an engineering mindset. So that's sort of one of the ways I direct them to go. So this is the start of the training slide. So, they're going to see they're going to hear 102, they're going to hear 103. That's probably the only code that inventors, like a code section that inventors are going to hear, and know and be part of their life. So, sometimes inventors will shy away and be like, oh, well, that's law stuff, but they're going to, it's just a shorthand way of saying novelty and non-obviousness. So what we tell inventors is that, for a novelty that, nothing maybe exactly like the claimed invention can be found in the prior art. And, what are they going to do with that? If you get a novelty rejection, you're going to review the claims line by line and highlight things that are required that aren't in the prior art. And that's an easy way for an inventor to help with a 102 rejection. Obviousness, obviously, it's a lot more complicated. So I've, put the question a bunch of different ways of, you kind of have to start with explaining the person of ordinary skill. And I often would say something like, look, it's, you're the inventor, you probably have extraordinary skill. I'm not a person of ordinary skill, but the guy in the office next to you, who's probably an ordinary skill, an engineering student 2 or 3 years out in the practicing your industry, he's probably of ordinary skill. So getting them comfortable with a person of ordinary skill is sort of the first step. And then, again, go back to the problem solution side of things. So if an ordinary person, a person of ordinary skill trying to solve the same problem as you was given this prior art, would they've arrived at, the claimed invention? And that's, and then when they say no, then we're drilling down on that. So these are kind of just some additional ways to ask the question and to step through and get to those factors that are in the legal, on the legal background slides. So, and finally, like to conclude, because again, I think obviousness is a difficult issue for inventors. I did provide, a couple of scenarios here for them to consider, and then we go back to my peanut butter and jelly sandwich, and in the first one, first reference is a traditional peanut butter and jelly sandwich that existed, and then the second sandwich is they kind of did the same thing, right? They used avocado and tomato paste, and they used the tomato paste to glue the sandwich shut. So was that obvious? I think it probably was. I'm sure we could argue about it. If I was the attorney, I would not concede, and I would argue that
103, Wes. That's 103.
Anyway, that's kind of academic point of view, and then, scenario 2, it's the same claim, but C2 is just a PhD thesis regarding the fluid dynamic analysis of how jelly will escape the peanut butter and jelly sandwich. So in that, I would say it's not obvious because it's just arguing about the problem, not talking about how to solve it. So that hopefully is just, 2 tidy solutions you can use to explain it with inventors, but you could certainly, flip these around and put them in the context of technology that they're used to, unless they like peanut butter and jelly sandwiches. Okay. Ed, any other thoughts on obviousness, or we cover it? Oh, you're muted. We can't hear you.
Yeah, it's a topic that could go on forever, and we could and maybe should have another webinar on just on this topic.
On teaching, I mean, it is and obviously, and we could have it on just teaching attorneys how to deal with it, but this was intended to kind of stay high level and give you kind of some plain language ways to explain it to inventors and some pre-canned samples and things like that you could show them. So okay.
All right, so for the next topic, we'll go from the heavy to a little bit lighter topic. So the topic here is what are the differences between patents and other forms of IP? Of course, nobody ever asks that. You hear this. Stop me if you've heard any of these before. You know, can we patent our logo? Can we patent the documentation? And then slightly different topic is, can we keep this part out of the patent application? So that comes up. You know, maybe they want a patent, but they still want to keep some of the secret sauce to themselves. And, you know, that gets into another kind of IP also. So if you go to the next slide. So, you know, obviously we have, besides patents, we have other forms of intellectual property that are more relevant to those questions, you know, trademarks, copyrights, trade secrets. You know, forget giving another webinar. Each of these areas of laws could be easily a semester course that we could teach. So it's hard to provide full legal background here, but I did provide that each one of those.
And I was just going to say to that point, it's hard to provide that. So hopefully the attendees will appreciate these are questions they need to cover, and these are easy slides to grab.
Yeah, for sure. Yeah, the training slides are a presentation I've given on this topic before to startup founders and are very useful for just kind of an overview of the different kinds of IP. So a little bit about what patents are, how they're used, trade secrets, same thing, trademarks, copyrights. That's all in your materials, so you can take that and use it for your own purposes. You know, adapt it as you see fit.
A lot, yeah, and depending on your business, you may need to drill down on these more, but I think it's good for anybody that's working with patents to at least be able to distinguish it when they say, "Oh, you work in patents." Oh, I got a patent on a song I wrote one time. So you want to at least give them the vocabulary to talk all IP and kind of know what to do. And if you have a more brand intensive company or something like that, you probably want to do a much more elaborate training on trademarks. So the last question is a pretty quick and easy one. Is what's my incentive to pursue patents? And this is something that I always try to, when I ask this question of in-house counsel, often when they're like, we're trying to get a hold of Inventors, he didn't review the draft, he didn't get back to us on something, or he, really was a half-hearted disclosure. And you get these responses, well, it's not my job, I'm just the engineer, I need to get this thing going. I mean, I've definitely had a situation where the inventor didn't review the draft and was working on an issue of national security and things like that. So there are things that are more important than reviewing the draft patent application. But that being said, make sure you've got a system in place that incentivizes it, and really like a clear incentive. So our last poll question is how do you motivate your inventors to submit more IDFs and participate in the patent process? And we're running a little short on time, so if you have
you may have other incentives also. We'd be interested to hear about those, but
yeah, I mean, if anybody has other incentives they want to put in the chat window, that would be worth it. That's actually, that's interesting that many haven't thought about it. It's something, I've seen companies that it's just $1,000 for every IDF for every patent. Maybe they wait till it gets filed as a U.S. application, or other ones they get kickback when it grants, or they get awards when they get to 10 patents, or we've some clients that have kind of elaborate stock awards and things like that. So you really want them to have skin in the game, and that's the goal. And quite honestly, they view their salary as being, that's for being an engineer. All this reading and writing that they didn't want to have to do when they graduated from engineering school, that's you got to motivate them a little bit more. So think about it. If obviously, talk to your attorneys and talk to other people about what they've seen. We can give other ideas for you if you need to. So.
Well, that was a lot of material to get through. in an hour, so I'm not sure we have much time for questions. But if anyone does have any questions, of course they can reach us. I think Anna, did you provide some contact information? And it's on the screen here also.
Yeah, I did, and I did put your contact into the chat. I'm not seeing any questions come through. That was a lot, but it was very good.
Yeah, I just throw one quick final thought is that, I mean, the reason Ed and I are so passionate about this is that we constantly get clients that want to save money and reduce their cost, and come to us and they're like, well, maybe we don't have to file here, maybe we don't have to do this, or why don't we reduce the fixed fee, or why don't we kill 6 patents we're not sure if we're going to need, all of that. Like, fundamentally get your system more efficient, and that will go a long way. Obviously you got to hold the line with your outside counsel and filing fees and maintenance fees and all of that. That's all important, but there's a real fundamental theme that often gets overlooked that you can address this with, and that's why we did this today.
I want to thank Wes and Ed for a very educational webinar. We are pleased to bring these webinars to you. Our next CLE webinar will be in September on trademark rights based on common law or federal registration. We will get a recording of this out to attendees. We'd appreciate it if you would fill out the evaluation form. And with that, gentlemen, any final words before we sign off?
No, just if you're interested in the IDF webinar as well, just email one of us and we'll send it to you.
All right. With that, everyone have a great day. Bye.
Thanks, everyone.